Question 1. In a high-stakes environment where multiple challenges arise concerning voting accessibility, a state legislature passes a law requiring voters to present a government-issued photo ID at the polls. Several civil rights organizations challenge the law, arguing that it disproportionately disenfranchises minority and low-income voters who may lack such identification, based on precedent and constitutional protections, which argument would be the strongest basis to challenge this law. A. The law violates the First Amendment by restricting political speech. B. The law violates the Equal Protection Clause of the 14th Amendment by imposing an undue burden on certain voters. C. The law violates the Second Amendment by indirectly limiting the rights of individuals who use their IDs for firearm purchases. D. The law conflicts with the Commerce Clause by interfering with interstate travel and business activity. Answer: B. The law violates the Equal Protection Clause of the 14th Amendment by imposing an undue burden on certain voters. Explanation: Voter ID laws have been a contentious issue in civil rights litigation. The Equal Protection Clause of the 14th Amendment prohibits states from enacting laws that disproportionately burden certain groups of citizens, including racial minorities and low-income individuals. In Crawford v. Marion County Elect Board, 2008, the U.S. Supreme Court upheld Indiana's voter ID law but acknowledged that law could be unconstitutional if it imposed an excessive burden on a specific class of voters. Option A is incorrect because the First Amendment primarily protects political speech, association, and expression, but voter ID law does not directly suppress these rights. Option C is incorrect because the Second Amendment pertains to gun ownership and regulation, which is unrelated to voting rights. Option D is incorrect because the Commerce Clause governs interstate commerce, which is unrelated to state election laws. Thus, the strongest challenge would focus on the 14th Amendment's Equal Protection Clause, arguing that the law disproportionately disenfranchises specific voter groups. Question 2. While investigating inconsistencies across various units of a national corporation, the Equal Employment Opportunity Commission (EOC) finds that female employees receive on average 20% less in salary than their male counterparts in the same roles despite comparable qualifications and experience. The company argues that salary differences are due to market forces and negotiation skills. Under the Equal Pay Act of 1963, which of the following legal principles is most relevant in determining whether the wage disparity is unlawful? A. The company must prove that the pay difference is based on factors other than sex, such as seniority or merit. B. The burden of proof falls entirely on employees to demonstrate that discrimination was intentional. C. Wage disparities are only illegal if they explicitly reference gender in company policies. D. If men on average negotiate higher salaries, the company is not liable under the law. Answer: A. The company must prove that the pay difference is based on factors other than sex, such as seniority or merit. Explanation: The Equal Pay Act of 1963 requires that men and women in the same workplace be given equal pay for equal work. The jobs do not have to be identical, but they must be substantially equal in terms of skill, effort, responsibility, and working conditions. Option A is correct because under the Equal Pay Act, once a wage disparity is demonstrated, the employer must justify the difference using acceptable criteria such as seniority, merit, quality of production, or any factor other than sex. The burden shifts to the employer to prove a legitimate reason for the pay gap. Option B is incorrect because the Equal Pay Act does not require proof of intent to discriminate, only proof that pay disparity exists. Option C is incorrect because wage discrimination does not have to be explicitly stated in company policies to be illegal. Option D is incorrect because negotiation disparities do not justify systemic wage differences under the Equal Pay Act, particularly if female employees consistently receive lower offers. Employers who fail to provide an acceptable justification for wage disparities can be held liable for back pay and damages. Question 3. During an emergency response where multiple areas are impacted, a city enacts a temporary policy allowing law enforcement officers to conduct random searches of vehicles in neighborhoods with high crime rates, citing urgent public safety concerns. A civil rights advocacy group challenges this policy, arguing that it violates constitutional protections. Under established case law, which legal principle would be the most effective basis for challenging the policy? A. The Fourth Amendment prohibits unreasonable searches and seizures requiring probable cause or specific suspicion. B. The First Amendment protects freedom of movement, preventing the government from stopping individuals without cause. C. The 10th Amendment reserves policing powers to the states, making federal intervention necessary. D. The policy is unconstitutional under the Commerce Clause because it affects residents' ability to travel between states. Answer A. The Fourth Amendment prohibits unreasonable searches and seizures requiring probable cause or specific suspicion. Explanation. The Fourth Amendment of the U.S. Constitution protects individuals from unreasonable searches and seizures by requiring law enforcement to obtain warrants based on probable cause, with limited exceptions. Option A is correct because random vehicle searches without probable cause or specific suspicion violate the Fourth Amendment. The U.S. Supreme Court has ruled in cases like Delaware v. Pras. 1979 that random vehicle stops without reasonable suspicion are unconstitutional. Additionally, in City of Indianapolis v. Edmond. 2000, the court struck down vehicle checkpoints used for general crime control. Option B is incorrect because while the First Amendment protects various freedoms, it does not directly prohibit random searches or vehicle stops. Option C is incorrect because the 10th Amendment concerns state versus federal power, which is not directly relevant to the constitutionality of the searches. Option D is incorrect because the Commerce Clause relates to business and interstate commerce, not police search procedures. Thus, the strongest challenge is under the Fourth Amendment, arguing that the random searches lack individualized suspicion and violate constitutional rights. Question 4. During a comprehensive review of a process that needs improvement, a city government is evaluating its hiring practices to ensure compliance with federal civil rights laws. The review finds that a long-standing policy requires all applicants to have a clean criminal record to be eligible for employment in any municipal department, even for positions that do not involve public safety or financial responsibility. Civil advocacy group challenges this policy, arguing that it disproportionately excludes minority applicants, violating Title Roman of the Civil Rights Act of 1964. How should the courts assess whether this hiring policy is unlawful under civil rights law? A. The policy is lawful because employers have the right to set hiring criteria that they believe best serve the organization. B. The policy is unlawful because it has disparate impact on minority applicants, and the city must prove it is job-related and consistent with business necessity. C. The policy is only unlawful if there is explicit evidence that it was created with the intent to discriminate. D. The policy is lawful because the Civil Rights Act does not regulate hiring based on criminal history. Answer. B. The policy is unlawful because it has a disparate impact on minority applicants, and the city must prove it is job-related and consistent with business necessity. Explanation. This question tests the candidate's understanding of disparate impact claims under Title IX of the Civil Rights Act of 1964. The key legal principle involved is that even if policy appears neutral on its face, it can still be discriminatory. This proportionally affects protected class and is not justified by business necessity. Option is incorrect because while employers can establish hiring criteria, they cannot use policies that result in unjustified discrimination under Griggs v. Duke Power Company, 1971. Option B is correct because the Supreme Court has held that employment policies with disparate impact on protected groups must be job-related and consistent with business necessity under 42 U.S.C. SS 2002 K1A. The city would need to prove that criminal history requirement is relevant to the specific job duties. Option C is incorrect because intentional discrimination is not required to establish Title IX or a violation under disparate impact claim. Option D is incorrect because while the Civil Rights Act does not explicitly address criminal history, the Equal Employment Opportunity Commission (EOC) has issued guidance stating that blanket bans on hiring individuals with criminal records can violate Title IX if they disproportionately exclude minority applicants. Question 5. When implementing new protocols in a shared environment, a state legislature is considering a law that would require all voters to provide proof of citizenship before casting a ballot. Civil rights groups challenge the law, arguing that it violates the National Voter Registration Act and disproportionately burdens certain groups of voters. The state argues that it has a compelling interest in preventing voter fraud and ensuring election integrity. What is the most likely legal analysis under federal civil rights law? A. The law is unconstitutional because it imposes an undue burden on the right to vote. B. The law is lawful because states have broad discretion to regulate elections. C. The law is only unconstitutional if plaintiffs can prove it was enacted with a discriminatory intent. D. The law is lawful as long as alternative methods of proving citizenship are available. Answer A. The law is unconstitutional because it imposes an undue burden on the right to vote. Explanation. This question assesses knowledge of voting rights laws, particularly the NRI and the Voting Rights Act of 1965. Courts have consistently ruled against laws that place undue burdens on voters without clear justification. Option is correct because under Crawford v. Marion County Election Board, 2008, and Arizona v. Intertribal Council of Arizona, 2013, courts have struck down overly restrictive voter ID and citizenship requirements when they disproportionately disenfranchise certain voters. Option B is incorrect because while states regulate elections, they must do so in compliance with federal law, particularly the NRA, which prohibits unnecessary obstacles to voter registration. Option C is incorrect because a facially neutral law can be struck down based on its impact, not just intent. Courts have invalidated election laws that disproportionately burden minorities, elderly voters, and lower-income individuals. Option D is incorrect because even if alternatives exist, the burden of providing citizenship documents may still violate the fundamental right to vote under the 14th and 15th Amendments. Question 6. In a situation where formal requirements conflict with practical enforcement, a local government is attempting to enforce a zoning ordinance that prohibits multifamily housing in certain neighborhoods. A group of tenants argues that the ordinance has a discriminatory impact on racial minorities and violates the Fair Housing Act (FHA). The city defends its policy, stating that the rule applies equally to all applicants, regardless of race. Correct legal analysis. A. The ordinance is lawful because it is race-neutral on its face and applies to all applicants equally. B. The ordinance may be unlawful if it has a disparate impact on protected groups, even without discriminatory intent. C. The ordinance is only unlawful if plaintiffs can show explicit racial discrimination in its drafting or enforcement. D. The ordinance is lawful because local governments have broad zoning powers under the 10th Amendment. Answer. B. The ordinance may be unlawful if it has a disparate impact on protected groups, even without discriminatory intent. Explanation. This question focuses on housing discrimination under the Fair Housing Act (FHA) and the disparate impact standard established in Texas Department of Housing and Community Affairs v. Inclusive Communities Project 2015. Option is incorrect because facial neutrality does not prevent liability under the FR's disparate impact theory. Option B is correct because under 42 U.S.C. SS 3604, plaintiff can challenge zoning rule that disproportionately affects racial minorities, even without proof of discriminatory intent. Option C is incorrect because while intentional discrimination cases require proof of intent, disparate impact claims do not. Option D is incorrect because local zoning powers cannot violate federal civil rights laws. The 10th Amendment does not allow states or municipalities to enforce discriminatory housing policies. Question 7. During an emergency response where multiple areas are impacted, a school district implements a policy banning students from wearing any political or social justice-related clothing to prevent disruptions. The student is disciplined for wearing a Black Lives Matter t-shirt and challenges the policy under the First Amendment. How should the court evaluate this case? A. The policy is lawful because schools have wide discretion to regulate student speech. B. The policy is unlawful because it discriminates based on viewpoint and violates the First Amendment. C. The policy is lawful if the school can show that the clothing would cause a substantial disruption. D. The policy is only unlawful if the student can prove it was enforced in a discriminatory manner. Answer. C. The policy is lawful if the school can show that the clothing would cause a substantial disruption. Explanation. This question examines student free speech rights under Tinker v. Des Moines Independent Community School District, 1969, and the balance between expression and school authority. Option is incorrect because while schools have authority over student expression, the First Amendment still applies. Option B is incorrect because viewpoint-based discrimination is prohibited, but content-neutral restrictions may be allowed. Option C is correct because under Tinker, schools may restrict speech if it causes a substantial disruption to the learning environment. Courts would analyze whether the Black Lives Matter shirt actually led to disruptions. Option D is incorrect because the rule can still be unconstitutional even if applied evenly. The key issue is whether it restricts protected speech without justification. Question 8. During a critical transition period where existing processes are being evaluated for compliance, a state legislature is considering new cybersecurity regulations for businesses handling sensitive consumer data. The proposal includes strict penalties for data breaches even if the company had reasonable security measures in place. Business groups argue that the law unfairly penalizes companies that experience breaches despite taking precautions. What is the most likely legal analysis of this regulation? A. The law is unconstitutional because it punishes companies without requiring proof of negligence. B. The law is lawful because states have broad authority to regulate businesses within their jurisdiction. C. The law is unconstitutional because it conflicts with federal cybersecurity laws. D. The law is lawful as long as companies are given a clear opportunity to defend themselves before penalties are applied. Answer D. The law is lawful as long as companies are given a clear opportunity to defend themselves before penalties are applied. Explanation. This question examines state regulatory authority and due process requirements in cybersecurity laws. Option is incorrect because strict liability laws exist in various regulatory contexts and are not inherently unconstitutional. Option B is incorrect because while states regulate businesses, regulations must comply with due process principles. Option C is incorrect unless there is a direct conflict with federal law, which would invoke the Supremacy Clause. Option D is correct because as long as companies have a chance to contest penalties and defend their compliance efforts, the law is likely valid. Question 9. In a high-stakes environment where multiple challenges arise simultaneously, a national healthcare provider implements a mandatory vaccination policy for all employees. Several employees challenge the policy, arguing that it violates their rights under Title IX of the Civil Rights Act and the Americans with Disabilities Act (ADA). What legal principles will determine whether the employer can enforce this policy? A. The policy is lawful because employers can mandate vaccinations for workplace safety without exception. B. The policy is unlawful because it violates employees' personal autonomy rights. C. The policy may be lawful, but the employer must provide reasonable accommodations for religious or medical exemptions. D. The policy is only lawful if the government explicitly mandates vaccinations for all workplaces. Answer. C. The policy may be lawful, but the employer must provide reasonable accommodations for religious or medical exemptions. Explanation. This question assesses employment law, religious accommodations, and medical exemptions under federal law. Option is incorrect because employers must consider accommodations under Title IX at the EDA. Option B is incorrect because workplace policies can impose restrictions provided they comply with civil rights laws. Option C is correct because employers can mandate vaccines but must allow accommodations for sincerely held religious beliefs or medical conditions under EOC guidelines. Option D is incorrect because private employers can set their own policies without a government mandate. Question 10. While investigating a complicated issue between different regulatory agencies, a federal agency proposes a rule that requires small businesses to adopt expensive new compliance measures. Business owners argue that the rule imposes an undue financial burden and challenge it under the Administrative Procedure Act, APA. What legal standard will a court use to review this regulation? A. Whether the regulation is necessary to protect public interests. B. Whether the agency followed proper rulemaking procedures and acted within its authority. C. Whether the regulation is unconstitutional under the Commerce Clause. D. Whether small businesses can afford the compliance costs. Answer. B. Whether the agency followed proper rulemaking procedures and acted within its authority. Explanation. This question focuses on administrative law and regulatory challenges under the APA. Option is incorrect because necessity alone does not make a rule valid. Option B is correct because courts review agency actions to ensure they comply with notice and comment rulemaking and do not exceed statutory authority. Option C is incorrect unless the regulation exceeds federal power under the Commerce Clause. Option D is incorrect because financial hardship alone is not a basis to invalidate a rule. Question 11. When implementing new protocols in a shared environment, a university requires student organizations to submit all speech-related event materials for approval before hosting public discussions on campus. A student group challenges this policy under the First Amendment, arguing that it constitutes prior restraint. What is the correct constitutional analysis? A. The policy is lawful because universities can regulate student speech. B. The policy is unlawful because it imposes prior restraint on speech. C. The policy is lawful as long as the university applies it equally to all student groups. D. The policy is unlawful only if it specifically targets controversial topics. Answer. B. The policy is unlawful because it imposes prior restraint on speech. Explanation. This question examines free speech rights at public universities and the doctrine of prior restraint. Option is incorrect because public universities must comply with First Amendment protections. Option B is correct because prior restraints on speech are generally unconstitutional unless justified by compelling government interests. Option C is incorrect because even neutral rules restricting speech can be unconstitutional. Option D is incorrect because all prior restraints, not just those targeting controversial speech, raise constitutional concerns. Question 12. In a situation where formal requirements conflict with practical enforcement, a police department enforces a local curfew ordinance restricting movement after 10 p.m. Civil liberties groups argue that the law violates the First and 14th Amendments. How will courts likely assess this ordinance? A. The ordinance is lawful because local governments have police power to maintain order. B. The ordinance is unlawful if it is vague or disproportionately enforced. C. The ordinance is lawful if it applies to everyone equally. D. The ordinance is unlawful because any restriction on movement violates constitutional rights. Answer. B. The ordinance is unlawful if it is vague or disproportionately enforced. Explanation. This question assesses due process and equal protection concerns in public safety laws. Option is incorrect because police powers must comply with constitutional protections. Option B is correct because vague laws or selective enforcement may violate due process and equal protection. Option C is incorrect because equal application does not always make a law constitutional. Option D is incorrect because reasonable restrictions can be upheld if justified. Question 13. While analyzing the root causes of sequential problems in consumer protection enforcement, a federal agency expands its authority to regulate online privacy practices. Tech companies challenge the agency's actions, arguing that Congress never explicitly granted this authority. What is the most relevant legal doctrine in this case? A. The Major Questions Doctrine. B. The Commerce Clause. C. The Rational Basis Test. D. The Chevron Deference Doctrine. Answer A. The Major Questions Doctrine. Explanation. This question tests knowledge of administrative law and agency power. Option is correct because courts use the Major Questions Doctrine to determine if agencies exceeded their authority without clear congressional authorization. Option B is incorrect unless the issue involves interstate commerce. Option C is incorrect because it applies to economic regulations, not agency power. Option D is incorrect because Chevron deference applies only if Congress has granted the agency discretion. Question 14. During a major transformation where existing methods no longer meet industry standards, a financial institution adopts AI-driven algorithms for approving or denying loan applications. Concerns arise that these algorithms unintentionally discriminate against certain demographic groups, violating federal fair lending laws. What legal principle will determine whether the institution is liable for discrimination? A. The disparate impact doctrine, which holds companies liable for policies that have an unintended discriminatory effect. B. The business necessity defense, which allows institutions to justify policies based on operational efficiency. C. The direct discrimination standard, which only applies if there is evidence of intentional bias. D. The First Amendment, which protects companies from legal challenges regarding proprietary technology. Answer A. The disparate impact doctrine, which holds companies liable for policies that have an unintended discriminatory effect. Explanation. This question examines fair lending laws. An algorithmic bias in financial decision-making. Option is correct because under the disparate impact doctrine, a policy can be unlawful even without intentional discrimination if it disproportionately affects protected groups. Option B is incorrect because while a business necessity defense can be used, it must still show no less discriminatory alternatives exist. Option C is incorrect because anti-discrimination laws also cover unintentional biases. Option D is incorrect because the First Amendment does not protect discriminatory business practices. Question 15. While examining inconsistencies across various units in a nationwide retail chain, management discovers that consumer protection laws vary significantly from state to state. The company wants to adopt a uniform return policy, but certain state laws impose stricter consumer protections than others. What is the best legal approach? A. Adopt a single nationwide policy based on the state with the strictest laws. B. Follow the laws of the company's headquarters state, overriding other state rules. C. Allow state-specific policies where stricter consumer protections apply. D. Challenge the stricter laws in court as unconstitutional under the Commerce Clause. Answer. C. Allow state-specific policies where stricter consumer protections apply. Explanation. This question focuses on state consumer protection laws and interstate business operations. Option is incorrect because overcompliance is not always practical or necessary. Option B is incorrect because a company must comply with each state's laws where it does business. Option C is correct because businesses must comply with stricter state laws even if they vary. Option D is incorrect because state consumer laws are generally upheld unless they directly burden interstate commerce. Question 16. In an environment where different components must interact seamlessly, a logistics company adopts automated tracking and facial recognition technology for security purposes. Privacy advocates argue that the use of this technology violates consumer rights under emerging state privacy laws. Which legal factor is most critical in assessing the company's compliance? A. Whether customers provide explicit consent for biometric data collection. B. Whether the company follows federal security standards for logistics operations. C. Whether the technology improves overall business efficiency. D. Whether the company operates internationally and complies with DDR regulations. Answer A. Whether customers provide explicit consent for biometric data collection. Explanation. This question addresses biometric privacy laws and consent requirements. Option is correct because many states require explicit consumer consent for biometric data collection. E.g. Illinois BIPA law. Option B is incorrect because federal security standards do not override state privacy laws. Option C is incorrect because business efficiency does not justify privacy violations. Option D is incorrect unless the company specifically falls under DER jurisdiction. Question 17. While managing a hybrid approach where timing issues affect performance, a pharmaceutical company faces delays in clinical trial approvals due to conflicting international regulations. How should the company address this regulatory challenge? A. Seek approval in the country with the fastest regulatory process and expand later. B. Challenge stricter regulations in court for delaying medical innovation. C. Work with global regulatory agencies to harmonize approval processes. D. Focus only on FDA approval and ignore international markets. Answer. C. Work with global regulatory agencies to harmonize approval processes. Explanation. This question focuses on global pharmaceutical regulations and compliance strategies. Option is incorrect because approval in one country does not guarantee acceptance elsewhere. Option B is incorrect because challenging regulations rarely speeds up approvals. Option C is correct because regulatory harmonization efforts, e.g., guidelines, help companies navigate multi-country approvals. Option D is incorrect because global pharmaceutical companies must consider international compliance. Question 18. In a situation where resource allocation becomes a major challenge, a state legislature considers mandatory water conservation rules for agricultural businesses during a severe drought. Farmers argue that the regulations violate their property and water rights. What constitutional principle is most relevant? A. The Takings Clause of the Fifth Amendment. B. The Due Process Clause of the 14th Amendment. C. The Commerce Clause, regulating water use across states. D. The Privileges and Immunities Clause, protecting farmers from discrimination. Answer A. The Takings Clause of the Fifth Amendment. Explanation. This question examines constitutional limits on state environmental regulations. Option is correct because if regulations limit landowners' rights too severely, they may be challenged as an unconstitutional, taken without just compensation. Option B is incorrect unless the rule targets certain groups unfairly. Option C is incorrect because state water laws do not necessarily burden interstate commerce. Option D is incorrect because water restrictions apply universally, not just to out-of-state residents. Question 19. During an emergency response where multiple areas are impacted, a state government issues an evacuation order during a natural disaster, but some residents refuse to comply, citing constitutional rights. What legal standard determines whether the evacuation order is enforceable? A. Whether the order is based on compelling government interests in public safety. B. Whether the order includes criminal penalties for non-compliance. C. Whether residents receive financial assistance for relocating. D. Whether the order applies only to specific communities. Answer A. Whether the order is based on compelling government interests in public safety. Explanation. This question addresses government emergency powers and constitutional limits. Option is correct because courts recognize that public safety justifies temporary restrictions on movement. Option B is incorrect because criminal penalties do not automatically make an order legal. Option C is incorrect because financial aid is separate from legal enforceability. Option D is incorrect because targeting specific groups could raise equal protection concerns. Question 20. In a multi-location scenario where consistency requirements vary, a company must comply with different state labor laws for remote employees. What is the best legal approach? A. Apply the labor laws of the state where the company is headquartered. B. Apply the labor laws of the state where each employee resides. C. Follow federal labor standards and ignore state laws. D. Let employees choose which state laws apply to them. Answer B. Apply the labor laws of the state where each employee resides. Explanation. This question concerns remote work and multi-state labor compliance. Option A is incorrect because an employer must follow the laws of the employee's work location. Option B is correct because employees are protected by the labor laws of their state. Option C is incorrect because federal laws set minimum standards but do not override stricter state laws. Option D is incorrect because employment law is not based on personal choice. Question 21. While analyzing the root causes of sequential problems in a supply chain, a manufacturing company identifies delays caused by inconsistent quality control standards across its suppliers. Some regions enforce stricter safety and testing regulations, while others have minimal oversight. What is the best legal strategy for ensuring compliance while maintaining efficiency? A. Apply the strictest regulations across all suppliers to ensure uniformity. B. Follow only the minimum regulatory requirements in each region. C. Develop an internal compliance program that meets the highest global standards. D. Require suppliers to self-certify their compliance, reducing the company's liability. Answer C. Develop an internal compliance program that meets the highest global standards. Explanation. This question explores supply chain compliance and regulatory inconsistencies. Option A is incorrect because enforcing the strictest standards may not be cost-effective. Option B is incorrect because meeting only minimum standards increases risk. Option C is correct because a company-wide compliance program ensures long-term consistency, quality, and legal protection. Option D is incorrect because self-certification does not provide legal protection against liability. Question 22. During a comprehensive review of a process that needs improvement, a healthcare provider discovers that electronic medical record EMA sharing across different states is inconsistent due to privacy laws. What legal principle determines whether EMAs can be shared across state lines? A. The Health Insurance Portability and Accountability Act, HIPAA, which sets national privacy standards. B. The Commerce Clause, which mandates uniformity in health information regulations. C. The General Data Protection Regulation GDR, which applies to all digital records. D. The Public Health Emergency Exception, which allows full disclosure of medical records. Answer A. The Health Insurance Portability and Accountability Act, HIPAA, which sets national privacy standards. Explanation. This question concerns healthcare privacy laws and interstate record sharing. Option is correct because HIPAA regulates EMA privacy at the federal level, though states may have stricter laws. Option B is incorrect because the Commerce Clause does not override state privacy laws. Option C is incorrect because DDR applies to European data privacy laws, not U.S. regulations. Option D is incorrect because public health exceptions are temporary and limited. Question 23. When implementing new protocols in a shared environment, a cybersecurity firm mandates multi-factor authentication (MFA) for all employees. However, some argue that this violates labor laws in states that limit employer control over personal devices. What legal issue is most relevant? A. Employee privacy rights versus cybersecurity requirements. B. The Fair Labor Standards Act's restrictions on employee monitoring. C. The First Amendment protecting employees' digital choices. D. The Americans with Disabilities Act, which prevents technology mandates. Answer A. Employee privacy rights versus cybersecurity requirements. Explanation. This question examines workplace privacy and security laws. Option A is correct because some states protect employee privacy in personal device usage. Option B is incorrect because FLSA covers wages, not cybersecurity policies. Option C is incorrect because the First Amendment does not apply to workplace cybersecurity rules. Option D is incorrect because MFA does not inherently violate disability laws. Question 24. In a high-stakes environment where multiple challenges arise, a company faces an antitrust investigation for allegedly restricting competition by entering exclusive supplier agreements. What is the primary factor in determining antitrust violations? A. Whether the agreements significantly limit market competition. B. Whether competitors file lawsuits against the company. C. Whether customers benefit from lower prices. D. Whether the agreements were made through fair negotiations. Answer A. Whether the agreements significantly limit market competition. Explanation. This question covers antitrust laws and competitive practices. Option is correct because antitrust laws focus on market competition, not just fairness. Option B is incorrect because lawsuits alone do not determine legality. Option C is incorrect because low prices do not excuse anti-competitive behavior. Option D is incorrect because even voluntary agreements can violate antitrust laws. Question 25. While investigating a complicated issue between different regulatory bodies, a company discovers that its advertising practices are subject to both federal and state consumer protection laws. Which legal principle applies if there is a conflict between them? A. The Supremacy Clause, which gives federal laws priority. B. The Dormant Commerce Clause, restricting state regulations on advertising. C. The Consumer Protection Act, which overrides conflicting state rules. D. The Preemption Doctrine, which determines whether federal or state laws apply. Answer D. The Preemption Doctrine, which determines whether federal or state laws apply. Explanation. This question involves federal versus state regulatory authority. Option is incorrect because the Supremacy Clause does not automatically invalidate state laws. Option B is incorrect because the Dormant Commerce Clause does not cover advertising laws. Option C is incorrect because the Consumer Protection Act does not override all state laws. Option D is correct because preemption determines whether federal law invalidates state regulations. Question 26. In a situation where formal requirements conflict with practical constraints, a real estate firm is required to disclose environmental risks to buyers, but compliance is costly and delays sales. What is the best legal approach? A. Fully comply with disclosure laws, regardless of costs. B. Lobby for relaxed regulations to reduce compliance burdens. C. Develop streamlined processes to meet requirements efficiently. D. Ignore less strictly enforced laws to speed up transactions. Answer. C. Develop streamlined processes to meet requirements efficiently. Explanation. This question covers real estate law and compliance strategies. Option is incorrect because while compliance is necessary, efficiency can still be improved. Option B is incorrect because lobbying does not provide an immediate solution. Option C is correct because streamlining compliance ensures legal adherence while reducing delays. Option D is incorrect because ignoring laws can lead to lawsuits and fines. Question 27. During the introduction of new methods where coordination is crucial, an airline implements autonomous aircraft maintenance systems. However, FAO regulations still require human verification for critical procedures. What legal issue is most relevant? A. Compliance with FAO safety regulations despite automation advancements. B. Workers' rights to challenge automation in the workplace. C. Passenger liability in case of system failures. D. Privacy laws restricting automated data collection. Answer A. Compliance with FAO safety regulations despite automation advancements. Explanation. This question explores automation and regulatory oversight in aviation. Option is correct because FAO safety rules take precedence over technological advancements. Option B is incorrect because this is a regulatory issue, not a labor rights matter. Option C is incorrect because passenger liability is unrelated to maintenance regulations. Option D is incorrect because privacy laws do not override FAO safety rules. Question 28. When developing a solution that must address opposing needs, a city must balance economic development and environmental protection when approving a new industrial zone. What is the best legal framework for resolving this conflict? A. Environmental impact assessments IA to evaluate long-term effects. B. Relying solely on economic benefits to justify development. C. Community votes to decide zoning regulations. D. Encouraging voluntary industry self-regulation. Answer A. Environmental impact assessments IA to evaluate long-term effects. Explanation. This question deals with urban planning and environmental law. Option is correct because IAs help balance economic and environmental concerns. Option B is incorrect because economic benefits do not automatically override environmental laws. Option C is incorrect because zoning laws are subject to legal requirements, not just public votes. Option D is incorrect because self-regulation is not legally binding. Question 29. While considering alternative approaches to resolve A significant dispute: a multinational corporation faces a lawsuit from multiple jurisdictions regarding its data collection practices. Some countries have strict data privacy laws, while others have more relaxed regulations. What is the most effective legal strategy for handling these conflicting requirements? A. Apply the strictest data protection laws across all regions to ensure compliance. B. Follow each country's specific laws separately, even if they contradict each other. C. Establish universal data privacy framework that meets the highest global standards. D. Only comply with data privacy laws in the corporation's home country. Answer: C. Establish a universal data privacy framework that meets the highest global standards. Explanation: this question examines global data privacy compliance and jurisdictional conflicts. Option is incorrect because universal strict compliance may be unnecessary and costly. Option B is incorrect because contradictory laws create legal risks and operational inefficiencies. Option C is correct because a unified, high-standard privacy policy ensures compliance across multiple jurisdictions and reduces legal risks. Option D is incorrect because ignoring foreign privacy laws can result in penalties and lawsuits. Question 30. In a scenario where multiple stakeholders have competing interests, a pharmaceutical company wants to fast-track a new vaccine during a public health crisis. However, regulatory agencies require long-term clinical trials to ensure safety. What is the best approach for balancing urgency and legal compliance? A. Request emergency use authorization while continuing safety trials. B. Bypass approval processes to distribute the vaccine faster. C. Wait until all long-term trials are complete before public release. D. Rely on private sector distribution without government oversight. Answer: A. Request emergency use authorization while continuing safety trials. Explanation: this question focuses on regulatory compliance and public health urgency. Option is correct because allows vaccines to be used in emergencies while ensuring ongoing safety testing. Option B is incorrect because bypassing regulations is illegal and unsafe. Option C is incorrect because delaying a vaccine in a crisis could cause unnecessary harm. Option D is incorrect because government oversight is required for medical safety approvals.